today's class. So last class we spoke about copyright. We spoke about yeah. We spoke about what is copyright and who it only protected for. What is the term of copyright? We saw all of that. We saw what is assignment and any issues we have to go to the commercial code. So that's also what we saw. So next is licenses by owners of copyright. Now the author of or the copyright owner has exclusive right in his creative work and he alone has a right to grant license in respect of his work. Right by license should be either in writing or through his authorized agent. To whom license relating to copyright in any future work is granted dies before the work comes to existence, his legal representative shall, in the absence of any provision to the contrary in the license, be entitled to the benefit of the license. Now, what happens is copyright we saw is something to do with literally, is something to do with drama, something to do with films, sound recording, computer programs, all of that is relating to copyrights. So what happens is copyright is basically anything that involves creative work. Copyright is something to do with that. So now who can give the copyright is none other than the author himself now. So the author should only sign the copyright, the license agreement, should give license grants to other people so that they can use the particular work. Now, the license should be due in writing. It must not be oral. It should be only in writing. If he does not give any, if he cannot sign any agreement, it needs to be by his duly authorized agent. Now, agent is someone who he appoints because he cannot do it himself. He'll appoint an agent, and that agent will have something with the power of attorney. He'll have a power of attorney. So, a duly authorized agent. Now, what happens? Say, for example, a movie is in process, and he's the script writer of the movie. Now he will take copyright for the upcoming movie. Say there is a movie that's coming up, so the writer will take a copyright much before the movie gets started. Before the actors start doing it, before the director comes on board, he writes the script and he takes a copyright for that. Now what happens is the writer will die. So once the writer dies, what happens? Then his legal representative shall have the permission of continuing the license for the particular script. So basically, if you're a scriptwriter for a particular movie, your script also will be copywritten. And if you die, your legal representative can sign the license and can give it to the directors for the movie. So that's what is called a license. So it needs to be in writing and it needs to be by the owner himself. No one else can give the license. 1 second. Next concept is compulsory license in works withheld from public. Now, withheld from public is something that a particular creative person, he does not allow anybody to doesn't allow anybody to perform that particular or use that particular his creative work. So during any term of the copyright, he would not give permission to the person to use it. Now that's compulsory. Now what happens is compulsory license in works withheld from the public. So basically, it is not known to the public, and it is performed in public. Then the complaint is made to the commercial court that the owner of the copyright in that work has refused to republish or allow the republication, or has refused to allow communication to the public by broadcast. So basically, if anybody wants the particular thing, they will go to commercial court and they will tell that this particular owner is not allowing us to use it, and it's very important that we use it. Then the commercial court will intervene and will give a compulsory license for the works, whatever the owner does not allow people to use it. So that's the concept of compulsory license in works withheld from public. Now, what happens is now there are certain unpublished and or published works. Now, in the case of any unpublished work or any work published or communicated to the public, the work is withheld from the public in India. Now, the author is died or unknown and cannot be traced. Now, the owner, so basically in this concept, the owner is not known. Then what happens is the owner of the copyright can or the owner of the copyright cannot be found. Then what happens? Any person may apply to the commercial court for the license to publish or communicate to the public such work or translation of the document of that particular work. So basically, if the owner is not found, so it's unpublished or it can be published, the owner is dead or it is unfound and they are not able to find the owner. But the particular, say, I'm just giving an example, say Mahabharata. Say if Mahabharata was a document which did not have, the person who wrote the Mahabharata was not there, he's not alive. Then what happens? Then they go to the court and they ask the court for compulsory license so that the book can be reprinted or translated. So basically, the court will give a compulsory license for those kind of cases where you cannot find the owner. Now, statutory license for broadcasting all literary and music works and sound recording. Now, any broadcasting organization. Now, who is a broadcasting organization? It's somebody who plays, your news, your radios, all that will come under broadcasting. Now, any broadcasting organization desires of communicating to the public by way of broadcast or by way of performance of a literary or musical work and sound recording which has already published may do so subject to the provisions of section 31B. Now, again, the broadcasting organization should take permission first, should take a particular license first. They will have to take permission from the owner. They will have to apply to the commercial court. They have to agree to pay the royalty, and then they have to use the particular music works and sound recording as broadcasting facility. Now, sometimes what happens is, say they want to put a simple example like an Audible. So you have a Kindle and an Audible will talk about it. Now it's a book and it talks. Now again, they need permission to convert the book into a voice thing. So what happens is they have taken permission, they pay royalty, and then they convert the entire thing to a voice. So when they are doing that, they shouldn't convert, they shouldn't change any word. They shouldn't change any language. Nothing has to be changed. They should just convert it as it is. Now, termination of the license. Now, we saw what is a license. When a license is issued, it can also be terminated. So basically, the owner itself terminates the particular license, say by a termination of agreement, or the term of the agreement gets expired. So these are the termination of license. So once the agreement is done, you cannot use it for any other purpose. So that's called a termination of license. Okay, anyone's got any doubt so far before we go to the next topic? Any doubts? Okay. Moving ahead, there is a concept of copyright society. Now, who is a copyright society? Now, it is a particular society like an NGO, not exactly an NGO, but it's like a Companies Act company, which is called a society. Again, they are a corporate body. They are an administrative unit who administers and who grants licenses for the copyright owners to other people. So basically, they help the owners, since owners cannot give the agreement sign licenses directly. They help the owners by which they issue licenses themselves. So a copyright society can issue or grant licenses in respect of any work for which it is authorized to by the authors or owners of the work. So basically, they are a part of the society. Now, if I write a book, I am part of a society, and I tell a society, see, I give you permission to license my work to anybody. So they will, whoever's interested can contact the society and they can get license for the particular book. Now, so copyright society is to accept exclusive authorization from an author and other owners of rights to administer any right in that work by issue of license, collection of license fee, or both. So basically, if I am publishing a book, I give the complete right to the particular society. Now the society has a right to issue licenses. The society has a right to collection of fees also. So they will collect the fees and they will give it to me, and they will issue anything, any licenses which also have to be given. They will issue that. Now the copyright society has the empowered to issue licenses, collect fees, and distribute such fees among authors or other owners of rights after making deduction of its own expenses, perform any other functions consistent with the provision. As I said, issue licenses, collect fees, distribute fees to the authors. They will take their expense fees also and perform any other function which is required. Broadcast reproduction right now. Section 37 entitles every broadcasting organization to have a special right to be known as a broadcast reproduction right in respect of its broadcast. The broadcast reproduction right shall subside until 25 years from the beginning of the calendar year next following year in which the broadcast is made. Now, basically, broadcast right is for the particular broadcasting company. As I said, say a news channel or a radio channel is called a broadcasting thing. Now, they have right to they have right of whatever they have read. I mean, whatever they have told in their channel, they can rebroadcast it multiple times. So they have their only they have the that's called a broadcast reproduction right. Now again, they only the broadcasting company, whoever has done it, can replay their news themselves. Now they can rebroadcast the broadcast, whatever they have played, they can always play that again. Causes the broadcast to be heard or seen by public on payment of any charges. So basically, if someone wants to use it, they'll have to pay a particular charge and they can use their broadcast. Makes any sound recording or visual recording of the broadcast. So basically, say if it's a podcast, you have heard of podcast. Now, if anybody wants to replay the podcast, they have to pay a particular fee and they have to use it. Making any reproduction of such sound recording or visual recording of such initial recording was done without license, where it was licensed for the purpose not engaged by such license. So basically, you again give licenses also. Say if someone wants to reproduce the particular sound recording or visual recording, they need to take license, and without license it will not be allowed. So any broadcasting, broadcasting need not be only radio, like your news channel. It will be your podcast. It will be various broadcast. So the definition of broadcast is quite vast. Now, in case if you want any sound recording or any visual recording, you can sell or you can rent the particular recording for a particular period. So they also have a license or a higher kind of a format. So you pay, you can play it. So they have that particular rights also. Now, a performer's right. Now, who is a performer? It's anybody who plays music, anybody who acts, anybody say who performs on a particular dance, anybody who reads. So the book, a person who book author reads also, that's also called a performer. Now, whoever does the performing has a right called a performer's right. This is a very important thing. So you can probably put a star mark in your books. this topic is important. So it might come because in most of say if you talk about copyrights, the most important thing would be performance right. What are the performer rights? Because performer rights is something which speaks about copyright as it is. So a person who performs their right. So the copyright revolves around a performer's right. So section 38, you can put a star mark there, you can revise it, provides that where any performer appears or engages in any performance, he shall have a special right known as the performer's right in relation to such performance. So, whatever you have performed, you have that particular right. The performer's right subset until 50 years from the beginning of the calendar year, next following year in which the performance is made. So, basically, performer's right is there for 50 years of the date performance has been made. Now, to make a sound recording or visual recording of the performance, including reproduction of it in any material, from including the storing any medium by electronic and any other means. So basically, you have the right. Now, if someone's making a sound recording or visual recording, the reproduction of that is your right. So basically, um, one second. Yeah, so basically, no one you will have to pay in case you want to reproduce whatever performance you have done. Issuance of copy to the public, not copying copies already in circulation. Now, in case if you want, if people want to make copies of your performance, you need to take permission. You need to take permission from the performer, and then you need to make issues of the copies. Say if it's book reading or something about the book or what you've spoken about. Communication of it to the public. So it needs to be communicated to the public. That's when your performer rights, if you've done it, if you have communicated it to the public, that's when it can be called as a performance right. Selling or giving it to a commercial rental or offer for sale for a commercial rental any copy of recording. So basically, sometimes what happens is if you see award functions, all of that, they do have um, it actually is done before, and then they have the particular channel will have the right to broadcast the particular award function. Now, whatever performance has been made it will come as a pack of a performer's right package to broadcast or communicate the performance to the public, except where the performance is already broadcasted. So basically, if it's not a live performance, then it needs to they need to pay the performer also, and then they will as and when say the time comes, they keep replaying those award functions. So whenever you see it, they keep replaying award functions. So every time it replays, the broadcasting channel or something will pay the performers for that particular award function replays. Now, there is a right called a moral right. Now, the author of a work has a right to claim authorship of the work and to restrain or claim damages in respect of any distortion, mutilation, modification, or any other acts in relation to the said work which is done before the expiry of the term of copyright. If such, modifications or any other act would be produced to his honor or reputation, moral rights are available to offer even after the economic rights are assigned. So basically, what happens is, say you have taken a copyright and you have given license to someone else for translation. Now, the particular translation has not done properly. So basically, translation means word to word translation. Say someone while doing the translation has uh, wrongly translated a particular word which means something else, which means something really bad, then what happens? Your reputation is at stake. So when the author gets to know that something like this has happened, what happens is he has a right to claim damages. So basically, he can file a case. He can claim damages against the particular whoever has not translated it properly. He has a right against them. So that's called a moral right. Now, even if say your copyright is on the verge of expiring, say a year before or 6 months before, and you find out that certain modifications have been done, then automatically you can file a case. So those are called moral rights for the author. Now, there is a copyright protection of foreign works. Now, whatever copyright is act is applicable, it is applicable only to the work whatever is there in India. So basically, whatever you have published in India, even if it's a foreign author, you are protected in India. So basically, if you are if the work is published first somewhere else, and then you come to India and then you publish it in India, what happens is, as per our act, there is protection for the foreign works also. So basically, you have published a book there, and then you come into India and you publish a book here, because it's already there in the foreign land and it's already famous. They give you a right to protect it even in India. So that's copyright protection of foreign works. Now, this came based on a convention. This was so there are various conventions. There's an international copyright order. There is a Berne Convention country. All of that. So you can go through that. Then there is a registration of copyright. Now, for a copyright, registration is not compulsory like a patent. Registration, if you do a registration, you have it as an evidence that it has gone into the registry, and you can claim saying that, see, I have already filed application with the copyright and I have received the copyright. So basically, only difference is, if you have not registered your copyright and in future someone kind of violates your right, then you can still file a case, but you need to prove it that it's your work. If you have registered the copyright, you can always show to the court that you have already registered and the person has copied. So basically, say for a script, a film script, you keep hearing in a lot of news saying that this script is mine, I have written this script. Someone else comes and tells, no, this script is mine, and then the original script writer will tell, no, the script is mine. So now that confusion happens because they have not registered their particular script and in the copyright. So if anybody has registered, so now tomorrow what happens, say a movie comes up and a particular person all of a sudden comes up and say, this particular script is copied from my script. You have cheated, you have taken my script and you have told it's your script, all that you see in the news. Now what happens then is, he files a case. Now he will have to prove in the court that it is his script, his is the original script. Now what happens is, the script writer, he has already registered in the court, registered in the copyright, saying that this is my script and I'm taking the copyright for it. He can always go to the court and say, see, I have written the script, I have taken copyrights for it, and this is the acknowledgement copyright copy. I have the, for so many years and I'm renewing it, all that. He can show it to him. He can give proof. So basically, that's the only difference. Both of them can file a case, but if you have registered, you can show it as a proof in the court of law. The register of copyrights is to be maintained by the Copyright Office to enter the names or title of works and the names and addresses of authors, publishers, owner of copyright. So basically, you have a concept of register of copyright. So whenever you go and you submit documents with proof saying that this is my copyright documents, they will, given all the details, they will maintain all your your names, your addresses, all of that. They will maintain and keep it. Now the registrar of copyrights, they have a power like civil court rights. So whatever court rights civil court has, they have the right of a civil court. Now in case if they want to summon anybody, if they want to if they want to require anybody for discovery and production of any document, any evidence on an affidavit, if they need, issuing commissions to examination witnesses, documents, requisiting any public record for a copy thereof from any court or any other matters as may be prescribed. Now all of this is the particular right of the registrar of copyright. These are all basically civil court rights. As and when someone files an objection, as and when someone files a case, then they have the right to summon, they have a right to ask for any production of any documents. If they need any evidence on an affidavit, to ask for it. Any commissions, witnesses, they can ask for it. Any public record which is required, they can ask. And any other matter whichever as may be prescribed. That means whenever the government feels right, they will mention it. Anybody's got any doubt?
No, ma'am.
Okay. Okay. So moving ahead, there is a workflow for a copyright registration. It starts with filing of application. So you will have to file an application with a particular fees. Now, once it is done, they will issue it in the diary. So they will give a diary number, and so basically, like a trademark or like a patent, it will be published so that the people can apply for objections. Now, what happens is they will issue for, so basically there are 30 days for an objections, for people to file objections. Now, for example, if I have taken a copyright for a particular script, once I file, they will put it for open public viewing for obligations. Now, if there is any obligation, so objections or no objections. So if there's an objections which is filed, then certain letters will be sent to both the parties, and then they will wait for both the parties to reply, and basically they'll have a hearing by the registrar, and to see whether the application will be accepted or rejected. Now, in case if it's accepted, then they will go in for issuing of the copyright. In case if it is rejected, then they will again have to ask both the parties on why it is being rejected. They have to give an explanation. The court will have to give an explanation on why they are rejecting it. Now, what happens is, in case if there's no objections, the officer will check everything, and if there is no discrepancies, they will issue the letter, and a registration will be submitted, will be approved, and a copyright certificate will be issued. So that is a workflow of how, whether from applying to getting the particular approval. So once the approval is found, they will get a copyright documentation, then they can keep it for their record. So that's nothing but a workflow of how a copyright registration from beginning to end happens. Now, there is a copyright infringement. Now, infringement is nothing but someone uses it, unauthorized use of someone's copyright work. Now, as I told yesterday, say you have played a music in a particular what do you say, in a particular say in a shop which you do not have permission, and then someone hears it. Okay, I'll give you an example. So what happened is, once there was a particular office party in a pub. Now, there was a pub and an office party, and people insisted that a particular song should be played, and they had displayed the office logo, all of that, in the particular pub on a big screen, and big music, all of that was played. At the same time, there was an agent from the from yesterday I explained, say if you're playing music from T series, you need to take license from T Series. Now you cannot take license from T Series; it will go through an agency. So there was an agent who happened to be there and realized that this particular company has not taken permission. He immediately sent a notice to the company saying that you have used the particular music in the public bar, which you are not entitled, and the company logo, all that was put. So he filed a case. So there was a compensation, requirement which had to be paid. So basically, if the company had taken permission from, say, T Series, they could have played it anywhere. But they hadn't taken permission, so that's why they had to pay compensation. Now that's called an unauthorized use of copyright work. Now, which are the common copyright infringement? Making infringing copies for sale or hire, or selling or letting them for hire. So basically, if publishing of books, if you've so you would have seen Harry Potter's, you get fake books. So basically, it's a similar thing, but you get it for cheaper. So those are making copies. So that is illegal. It is infringement. Permitting any place for performance of work in public where such performance constitutes infringement of copyrights. Like I said, playing music, if you're not authorized to play music in shops, in a lifestyle shop, you will see it in Reliance Trends shop. Everybody plays music now. If you're not authorized to play such music, you can be held liable. Distributing infringing copies for the purpose of trade, and to such extent as to affecting previously the interest of the owner of copyright. Now, the Harry Potter book, you've printed it for cheap and you're sending it to Singapore, Malaysia. That's also called a copyright infringement. Public examination of infringing copies by way of trade. So you're trying to sell it to public, saying that, see, this book is cheaper, it's got the same content. You are promoting your infringed work, which is wrong. Importation of infringing copies into India. Now, someone else has done a fake job outside and you're bringing it into the country. Now, that's also not allowed. Now, there are certain exceptions to this, where it is not called an infringement. There are how many points? 15, 16, 17, 18, 20, 21, 22, 25, 26. I think there are close to around 33 examples of, let me just share this. Just 1 second. I'll just join back. Give me 5 minutes, please. If you are using any computer programming, or for the purpose of private or for personal use, so if you're using it for any research, and if it's a patented computer program, then it cannot be called an infringement. If you're using it for criticism or review, now there's a particular computer programming that has come up, and you want to give a review about it, or you want to criticize it, then it is not called a infringement. Reporting of current events and current affairs. Now, okay, so basically this is for not being a computer program. So for any other work, so basically if you're writing a movie review, or if you're trying to report the current events or current affairs, then, or you're giving a lecture in in public, it cannot be amount to a infringement. Making copies or adaptation of a computer program by lawful possessor of a copy of such computer programming. So basically, if you're making copies, if you're making backup copies, if you're making backup copies or of the computer programs, then you cannot be called as a infringement, because you have the right to make those particular copies. Third one, if you are independently created a computer program with other programmers by a lawful possessor of a computer program, in provided that such information is not otherwise readily available. Now, you need, when you're making a particular program, you need to use another program, and use it for creating your current program. So then it is also not called an infringement. Any observation, any study, any test of consumer programming, it is not infringement. Making copies or adaptation of a computer program from a personally legally obtained copy for non-commercial use. So basically, so sometimes you have Microsoft, all of that you kind of you pay and you kind of get. So that is, you are buying the license. Now, if you are studying or if you're testing the particular software, then it is not called a infringement, because you're using it for your personal use. It is for non-commercial purposes. So basically, any personal use, if you use anything for personally, then it is perfectly all right. It is not infringement. The transient or incidental storage of work or performance purely in the technical process of electronic transmission or communication to public. Now, what happens is sometimes they store softwares, say they store your work for any future use. You have not given anybody any license, but you contact a particular agency for storing of your work. Now, storing of your work does not mean people will use it for reproduction and all that. It is for your use only, for a future communication to public process. Now, what happens is sometimes if you are a singer and you want to give anybody a link of your performance, and you ask some agency to convert your performance to a particular electronic link, then that is also not called as infringement. You are asking someone to help you to convert it into a particular link. Then so sometimes what happens is in the court of law, they ask for proof, and when they ask for proof, it is called a judicial proceedings. Now, while doing a judicial proceedings, they will ask you to produce your work, they will ask you to reproduce your work. So that is also not infringement. Now, reproduction of or publication of any work prepared by the secretariat or registration or both houses. Now, whenever they have, you would have heard that, the upper house, the lower house has given, passed this bill or has passed this bill. Now, you are trying to reproduce that. You are trying to give an explanation about whatever they have passed. Now, that is also not called as infringement. Any certified copy made or supplied in accordance with any law for the time being in force. Now, many a times, if you would have studied Companies Act, there in Companies Act, there is a concept of certified true copy of resolutions. Now, what is certified true copy of resolution is you're giving a resolution copy. Whatever the company has passed, whatever the board of directors has passed, you are giving a certified true copy to the authorities. Now, that is again called reproduction. Reproduction, giving of certified true copy. That is also not an infringement. Reading or recitation in public of reasonable extracts from a published literary or grammatical work. Now, sometimes what happens is people kind of give examples that, this book has written like that, that book has written like that. Now, giving examples or reading one line, two line in public is not called a copyright infringement. Any instructional use. So basically, you're using any book for any instruction purposes, then it is not infringement. Remember these 35 points. You do not have to remember word by word. You can just remember what it means or what it's trying to do. And say if it is for 5 marks, 10 marks, you can write 20 points. You don't have to write all 35. You don't have to remember all 35 points. Whatever you can remember for that many marks, double the points you can mention. You do not have to remember all 35 points. Reproduction of any work by a teacher or a pupil in the course of instruction. as a part of questions to be answered in an examination or in answers of such questions. Now, whatever examples you write in the examination, all that is not called an infringement. It is a part of, say, a part of the syllabus or part, if you give any examples, or if any teacher teaches. So, if I'm giving you any example of any company or any news article, all that is not called an infringement. Performance in course of the activities of an educational institutions. Yesterday I explained, if you have a dance competition in college or in school, that does not mean you are infringing it. Now, because why? Because you are only doing it for a limited audience, for the schools. So that's why whatever dance performance you do, all of that would not amount to as infringement. 1 minute, please. Okay. So the next is the causing of recording to be heard in public by utilizing it. 1 second. Say in a club or a residential complex or a society, they have performances, they have dance performances, they have singing competitions, all of that. Now, if you have performed anything in a society or in your apartment complex, anything, all that does not amount to as infringement. The performance of a literally dramatical musical work by an amateur club or society. Now, a best example is Ramayana. Now, Ramayana is performed every time by everybody. So you will find it in residential complexes. You will find it by a particular society. Any school, any colleges. Everyone will perform the Mahabharata. Say the Ramayana during Dasara festival. So what happens is that is allowed, as it is not called as infringement of copyrights. The reproduction in a newspaper, magazine, or any periodical, unless the author has expressly reserved to himself the right of such reproduction. Now, what happens is if you are writing, if an author of a book, say a particular famous writer has written a particular book, and someone is reproducing that particular information in the book, in the newspaper, or giving a particular picture or reproducing it. Now that is not called an infringement. And if the author has given permission saying yes, you can review my book, or you can add clippings, all that, that is not called a reproduction. The storing of works in any medium by electronic means by way of non-commercial public library. So basically, if you are keeping a particular work in a public non-commercial public library, that is also fine. Basically, it is not copyright infringement. 3 copies of a book can also be kept as in the commercial non-commercial public library. So basically, if you see your uh, public library, government public library, you will have copies of it, and it is free of charge. The reproduction for the purpose of research or private study with the view to publication of an unpublished literary drama in a library museum. So basically, if there are people who are doing research, now basically dinosaurs, if someone has written about dinosaurs and someone wants to do a research on it and write research papers or study and all of that. So all in all those cases, you can do that, and it is not a copyright infringement. Reproduction of publication of the official gazette. Now that is not infringement. Any act registration subject to the condition that the act is reproduced or published together with any commentary thereon or any other original matter. So in case if you are trying to reproduce a particular section of a particular act, for example, the textbooks, because one, it is for educational purposes. Two, it is also you are using information of the particular act. Now, that also, it's not copyright infringement. A report of any committee, commission, council, board, or any other body appointed. So sometimes you have certain committees like SEBI committee or SEBI board, all of that, and they give certain they give certain board meeting outcomes, all of that. Now, if you reproduce that, it is not copyright infringement. Any judgment or any court order also, if you reproduce it, it is not called an copyright infringement. The production or publication of a translation in any Indian language of an act or a registration. So, if company's act is in English and someone's translating it into Kannada, someone's translating into Malayalam or Marathi, all of that, it is not a infringement of copyrights. Making or publishing of a painting, drawing, engraving, photograph of work, architecture, or the display of work on architecture. Now, what happens is you go to Hampi and you find it very beautiful and you take photograph and you publish it in your Instagram, Facebook. All that is not a copyright violation. Any work whichever is public, whichever is put in public space, like say your sculpture or any painting, any drawing which is appearing in public, and someone copies it, or someone takes a photograph of it, again, all of that, if it is there in the view of public and if you're using it, it is not a copyright. Any artistic work permanently situated in a public space or any premises which allow public to access is not a violation. So basically, sometimes you go to say a government, what example, say you go to a theme park and then there's a music that's playing back to back, a particular music which is played throughout the theme park. Now that is in for a public. So if someone copies that music, it is not violation. By use of any author of an artistic work where the author of such work is not an owner of the copyright of any mold, cast, sketch, plan, model, study made by him for the purpose of the work, he has not thereby repeat or imitate the main design of the work. So basically, if someone uses a similar kind of a model, similar kind of a sketch, a mold, and they have not taken copyright ownership, and if it's publicly available, if you make copies out of it, it's not copyright. You're making a 3-dimensional object from a 2-dimensional object is also perfectly all right. Reconstruction of a building or structure in accordance with the architectural drawing or plans. So now there are particular drawing and plans, and the particular, say, phase 1 was done by a builder, phase 2 is being done by a builder. So then it is not called copyright violation. Now they talk only about architectural structures. In relation to literally dramatic, recorded or reproduced in any cinematographic film, the exhibition of such film after the expiry of the copyright term. So after the copyright term, if someone uses the particular thing, it's not called a copyright infringement. Importation of copies of any, so if a news agency, where did I? If any news agency, broadcasting organization wants to repeat their own broadcast, they have the right to repeat their own broadcast. They do not. It's not a copyright violation. Now, in case if any performance in the central or state government, if someone uses that particular for marriages in the state government offices or festivals, all of that, it is a religious ceremony. It is not copyright. Adaptation or reproduction, issuing copies to communication to public is also not for educational and personal use. It is not copyright infringement. Importation of copies of any literary work, such as label, company's logo, for or explanatory material that is purely incidental, being imported lawfully. So basically, if you're getting something in the country for adaptation, company logos, then it is not violation of copyrights. Okay, moving ahead. Yeah. 1 second. Remedies against infringement of copyright, which means if someone does any infringement, you get certain damages. So basically, damages accounts. If someone uses your copy unlawfully, you get there are certain remedies to it. Now, what are the remedies? And there are civil remedies, there are criminal remedies, and there's border enforcement. Now, civil remedies means injunction. Injunction means stopping from publication of the particular copyright violation. Damages, in case if it's already being in public circulation, whatever damage has been caused. Interpretation of accounts, delivery, destruction of infringement copies. So basically, they will ask you to destroy copies which has caused damage, which has been copyrighted. If it's clothes, if it's Puma violated clothes, they will ask you to burn all the clothes, destroy it. Criminal remedies, it's for CRPC. You have imprisonment, you have fines, you have seizing of infringing copies, delivery of infringing copies to the owner. So if someone's copyrighted Harry Potter books, they will ask it to be sent back to the owner. Border enforcement also provides that prohibition of import and destruction of any imported goods that infringe the copyright of a person with the assistance of the Customs Authority of India. So basically, if you're getting infringed copies of any copyrighted product, and if they find out that it is an infringement, then with the assistance of the Customs Authority of India, they will destroy all that imported goods. So basically, you cannot bring it into the country. It will be destroyed at the border if it is a copyrighted violation. So okay, so we are done with copyrights. Any copyright has its own time period, or the term of copyrights? Yes. So let me go back to the slide for you. So term of copyrights you will see in page number 499. So basically this page number is the Adobe Reader page number. So if actual 499 is nothing but, I'll tell you all for you all which page number. Number 462. So it's usually for, there are 5 works. Literally, dramatic, musical, and then you do have cinematography, you have sound recording, you have artistic work, and you have computer programming. Now, for all of it, there is a particular term. So, generally, for everything as such, it is 60 years from the date of, from the beginning of the calendar year of the first production. So, basically, 60 years is for all, but in page number 462, they have given for each thing individually. So in the exam, if they ask term of the copyright, you need you shouldn't give just say 60 years, but you will have to individually mention that for dramatical it's 60 years, for musical 60 years, computer programming 60 years. You'll have to mention it like that.